Good evening, everyone. And I am very happy to welcome you to the third session of the professional lecture series on Foreigners Tribunal practice, organized by the Assam State Legal Services Authority and Parichay Legal Aid Clinic. Today's session is the third of four sessions focusing on important issues of citizenship determination and practice before the FTs in Assam. Our session today will focus primarily on how to prove linkage without documentary evidence, and the session will be led by Advocate Debasmita Ghosh. Before we start, a brief introduction to this session as well as Parichay's work. These sessions were conceived of and were planned in order to address the lack of appropriate legal training and resources available to foreigners tribunals lawyers while representing cases of citizenship determination at the FT level. We understand that legal aid is an important component of defending everybody's right to citizenship. And for that, it is important that everybody gets equal access to resources, to training, and information. These sessions were planned along with the Assam State Legal Services Authority in order to further the need and further and advance the resources available for legal aid in the state of Assam. Parichay is a legal aid clinic set up in 2019 to assist lawyers practicing before FTs in Assam. And we put students in touch with lawyers and in order to assist them in doing research, in drafting, and in representing their clients before the foreigners tribunals. Parichay provides litigation and research support to lawyers, conducts research in the area of citizenship law in Assam, and our goal, as well as the SLSA's goal, is to strengthen the institutional strength of legal aid systems in the area of citizenship law. These four sessions that we have planned have so far focused on different aspects of practice before foreigners tribunals. The first session, which was led by Advocate A.R. Sikdar, focused on preliminary challenges to jurisdiction. The second session, that was led by Advocate Zakir Hussain, focused on drafting skills in FT cases. Tomorrow's session, which will be led by Advocates Zakir Hussain and Talha Abdul Rahman, will focus on final arguments and will include a demonstration on how to do final arguments. These sessions would not have been possible without the enthusiastic support and involvement of His Lordship Honorable Justice N. Kotiswar Singh. Unfortunately, he's a little unwell and he has not been able to join us for these sessions, but we know and recognize that his support has been crucial to making these sessions possible, as well as the support of everybody else at the Assam State Legal Services Authority, including Mr. Nayan Shankar Parwa, Ms. Ayushi Shravan, and Ms. Tripti Ari. Before we start, I want to just quickly take us through the housekeeping rules for today's session. I request everybody to please keep your cameras, not your cameras, your microphones on mute while the session is taking place. If you have a question and we want everybody to ask questions, please either use the raise hand option that is there at the bottom of your screen under reactions, or you can also type your question in the chat box. If you type your question in the chat box or if you use the raised hand option during the question answer session, we will ask you to please unmute yourself and ask your question. In addition to this, I want to emphasize that the session will take place for Ms. Debasmita ma'am session will take place for the first hour, at the end of which for the next hour, we will have questions and answers only. Please reserve your questions for that last hour between 7 to 8. And the session will take place between 6 to 8. We will be from time to time sharing links to cases that Devasmita ma'am is referring to. So if she's referring to any case, we will provide a link to that case in the chat box and you can open it and see. We will also be sharing our screen so people can see what case and what paragraph you're referring to in that case. Lastly, all of the resources, all of the case laws, all of the materials that we have compiled for these sessions will be shared with all of the participants at the end of the session. So please share with us. If you have not shared with us already, please send us your email ID and your phone number. There is a form, a Google form that is there in the chat box. Please enter your phone number and your email ID in that form, and we will be in touch with you to provide you all the necessary materials that we have referred to in this session. So without further ado, I will ask my colleague Shardul to please come forward and introduce Debasmita ma'am. Shardul will also be moderating today's session, so all questions and answers shall be taken by Shardul only. Thank you, Shardul, and please take over.
Thank you for the introduction, Darshana. It's been wonderful to see so many foreigner tribunal advocates from Assam joining us across the 2 weekends for these sessions. And the videos from last week's sessions also will be accessible on our YouTube channels, whose links we'll be sharing in the chat box. And we're also extremely grateful to the Assam State Legal Services Authority for facilitating and making these sessions a reality. We hope everyone here has been able to take much from these sessions and put it into their litigation learning. We're extremely pleased today to have with us Advocate Debasmita Ghosh for today's session on proving linkage without documentary evidence. Debasmita ma'am is the director of the Assam State Unit of the Human Rights Law Network, which started in 2008 and also litigates in multiple foreigner tribunals across Assam and at the Gauhati High Court. She has extensively argued cases in the domain of citizenship determination, and her work at HRLN has been instrumental in bridging a vital gap that exists between the issues of documentation and lack of representation that is prevalent across multiple districts in Assam. We're pleased to have you with us here, ma'am, and thank you for joining us today on this extremely important and vital session. With that, I'd like to just reiterate the housekeeping rules and would request everyone to send in all their questions towards the end of Debasmita ma'am's session or through the course of a session in the chat box. Once we open the floor for questions, you could all the ones having questions could raise their hands and I could come individually to each of you and take your question, which will then be subsequently answered by ma'am. Without any further ado, I would hand it over to Debasmita ma'am now to begin the session. And again, welcome everyone, and I hope everyone likes the session. Thank you.
Thank you so much. And it's really an opportunity for me to share my experience dealing with the cases of Foreigners Tribunal before the Foreigners Tribunal as well as before the Honorable Gauhati High Court. So basically, today's topic, which I was supposed to discuss, is on the oral evidence, means without any documentary proof, where only through oral evidence to establish the linkage between either maybe between the father and the proceedee or with the grandparents or with the father and all. Section 50, I'd like to state Section 50 of Indian Evidence Act, opinion on relationship when relevant. So with that regard, when the court has to form an opinion as to the relationship to one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who, as a member of a family or otherwise, has special means of knowledge on the subject is a relevant fact, provided that provided that provided that such opinion shall not be sufficient to prove a marriage in proceeding under the Indian Divorce Act. So, with relating to our foreigners tribunal cases, suppose if we don't have a documentary proof, any relative, that means either a father adducing evidence for his daughter or son, so establish the linkage. So tribunal can consider that opinion when, and this has been clearly established in, and it has been stated in Hyder Ali's judgment. If we see Hyder Ali's judgment, which is reported in 2021 3 GLT 85, page number 85. In that, it's quoted in paragraph, if I'm not wrong, it's paragraph 30, paragraph 41. And so, and in that entire judgment, it not only speaks about the oral evidence, that means opinion on establishing the linkage. It also speaks about certain disclosure of, if a certain disclosure of facts, it's not mentioned in the written statement, paragraph 31 of that document, of that judgment, paragraph 31, which is reported in GLT. I would like to read. Uh, Paragraph 31, which is very important. Entire judgment, I would like to say that the entire judgment, if you like, the observation by the tribunal that the proceeding ought to have disclosed all material facts in the written statement, which is within the spatial knowledge, and if the same is not disclosed, an adverse inference can be drawn against him, does not appear to be sound either in logic or in law. That means, which is not stated in the written statement or in evidence, but during cross-examination it has been stated, that that cannot be discarded, stating that this material facts was not disclosed before the tribunal. Same, this also states about section 50, and specifically section 59, which speaks about oral evidence. It also states that paragraph 42, paragraph 42 of the said judgment, paragraph 42 of the said judgment, yes, place of birth and all its disclosure. And it speaks in point number 4. If we just see point number 4, further, it is nowhere mandate that he must prove all these facts by documentary evidence only. It clearly says that section 59 of the Evidence Act says that all facts except the contents of documents or electronic records may be proved by oral evidence. So, or through oral evidence. So, contents of not the documents, but this is very important. And there may be cases where the proceeding is an illiterate and the birth is not registered with any authority, in which even it would be impossible to produce any documentary evidence to prove his date of birth and place and other facts accurately, and one may rely on oral evidence only. In such a case, can a claim be thrown out merely because only oral evidence been led? Further, after he has given evidence on this point, the state authorities can verify the facts and can lead evidence in rebuttal if necessary. So if oral evidence is led by the proceeding, and if there is no rebuttal to it, that means it's they are admitting to it. And even paragraph 26 of Sarbananda Sanbal, which is also been quoted here in paragraph 49, 41 of this judgment. Paragraph 41 of this judgment, Honorable Gauhati High Court has quoted Honorable Supreme Court's paragraph 26. So initial burden is upon the proceeding, date of birth, place of birth, but if there is no rebuttal to it, and if we see, and even my experience, I will always state that we always state, if it's prior to 69, we always state that the act was not there. When the act, registration of births and deaths act, it came in the year 1969. And if we see, it's not even at the present also, it's not even been properly implemented. There are various studies which says that and even the child rights organizers, they have made a study that till now also there are more than 15% of births are not yet been recorded. And if we see, most of these cases are cases of marginalized section. And in this sort of cases, marginalized section of the people are being targeted. So for that reason, they don't have their birth certificate. But they can state the place. Yes, in our written statement, if we clearly state that a place of birth, then here the date of birth, exact date may not be there, but here we can mention. So, and that can be corroborated if, because documentary evidence is not there, but sometimes a birth attender, because in the village areas, in the village areas, what happens, the birth takes place at home. So to assist the mother in the birth process, birth attender are there. So in local town, we call it daima. So if such persons are available who have assisted the birth process of the proceeding, can lead evidence, can lead an oral evidence to prove the birth of the concerned proceeding. Even in fact, we have done in many cases. Here before the learned tribunal, in many cases we have stated that we had brought as an oral evidence the birth attender to prove the birth. And in fact, registration of births and death 1969, later on also birth certificate can be procured through magistral, there is a process, and through that process also that birth certificate can be obtained subsequently, and that birth certificate can be produced. But if I'm stating that if there is no evidence, that means a concerned person doesn't have any documentary evidence to prove the date of birth or place of birth. So in that absence of that date of birth or place of birth, so this oral evidence can be relied upon, and which has been clearly stated in recent two judgments of our Honorable High Court. One is Hyder Ali, which already is being screened. Abdul has showed that, and one is next one. That judgment is of Sujabali, is of 2021, 4 GLT 664. In that judgment also, this is subsequent to the Hyder Ali's judgment. Sujabali, in that concern paragraph is paragraph 15, which says the impugned order of the tribunal also does not refer to the evidence adduced on behalf of the proceeding. Paragraph 15. Yes, proceeding petitioner, as has been upheld by the apex court in Dol Gabinda Parichay in respect of section 50 of the Evidence Act, that there are three essential requirements to section 50 of the Evidence Act, namely, number one, there must be a case where court has to form an opinion as to the relationship of one person to another. In such a case, the opinion expressed by conduct as to the existence of such relationship is a relevant fact. I pause here for a while. In such a case, the opinion expressed by conduct. So in the written statement or in the evidence, it can be clearly stated that, so and suppose a brother is adducing evidence for the proceedee who is his younger sister. He can clearly state that that so-and-so is my younger sister, and we brought up together in the same family. All the details can be stated, what conduct they did, so they studied together or they've been brought up in the same family. So if it's clearly mentioned, then also this is suffice. So it's section 50. Section 50, which clearly states that, and the entire paragraph of this, and then, but the person whose opinion expressed by conduct is relevant must be a person who is a member of the family or otherwise has special means of knowledge on a particular subject of relationship. In other words, the person must fulfill a condition laid down in the later part of this section. So maybe a family member, or sometimes may not be a family member, suppose a neighbor. Sometimes a neighbor adducing evidence, elderly neighbor adducing evidence, oral evidence, sometimes parents are not there, both the parents are not there. At times, because in many cases, we find that. So there is no one to adduce evidence. Near and dear ones, family members are not there. But neighbor is there. Because all of them has expired, her near and dear ones has expired. So the person who is adducing evidence is the neighbor. Neighbor can state that since childhood, I have seen her there. We played together. I know that person's mother, father, mother is so-and-so, father is so-and-so, or father and mother both are expired. Even she had brother, they expired. But we were being brought up in the same locality. We played together. We went, even we went. I had attended her marriage, or maybe whatever might be. Means in case of male, female, whoever it is. So can state that this also clearly states, means if we say this component, that means she is trying to establish her existence through oral evidence. Apart from any documentary evidence. So this judgment paragraph 15 is very important, Sujab Ali versus Union of India, which is again reported in 2021 4 GLT 664. Because it's always better in tribunals, my experience says that, to rely upon our High Court's judgment. Because our High Court's judgment, when we give the citations, it's very easy to get our orders from the tribunal. Because I'll just share my experience. It's because before High Court has passed an order with regard to Abdul Quddus judgment, even many tribunal interpreted Abdul Quddus differently. So for that reason, I prefer to rely upon our High Court's judgment in dealing with the cases. So oral evidence, these two are the vital judgments. And another one judgment which is very important with regard to, sometime we call to suppose a documentary evidence we have submitted, like a school certificate or so, and notices are being issued. But still, after notices are being issued, they are reluctant to come. In many of our cases, it happens because you all are dealing with the cases in tribunals, you know that, and my experience also shows that. But same our High Court's order, it's a order is passed in Nasima Begum's case, which is WPC 8838 of 2019. Where it says that tribunal has the power to summon, because earlier notices has been issued and the headmaster did not appear. May I read? The petitioner studied in Indira Gandhi LP school, and the headmaster of the school issued a certificate displaying the petitioner to be the daughter of Sultan Ansari. In fact, this is the only document showing her linkage with Sultan Ansari and Sultan Mia. For the same purpose, the petitioner produced two other documents, namely Gaubura certificates and certificate so and so. So far as school certificate is concerned, the tribunal, albeit as the behest of the petitioner, issued summons to the headmaster, but the headmaster did not appear before the tribunal. Therefore, bailable warrant of arrest was issued against the said headmaster. Finally, the tribunal issued non-bailable warrant of arrest on 13 so and so for securing the presence of the headmaster of so and so school, but police did not execute the said warrant of arrest. On so and so, the tribunal passed two orders asking so and so to produce the aforesaid headmaster of the said school, but endeavor of the tribunal to prove to be futile. Therefore, on 16/3, the tribunal again passed a similar order to execute the warrant. This was also nothing happened. On several dates subsequent thereto, the tribunal passed different orders for securing the presence of headmaster. Finally, the tribunal delivered the opinion without examination of the headmaster and declared the petitioner to be foreigner. So at least in this case, High Court, in this case also, it appears that tribunal acted half-heartedly while trying to enforce the attendance. So tribunal should make sure the attendance of the person concerned. Sometimes we issue notice, they don't come. Even the Gaumburas, they don't come. So the tribunal members, they have the power to summon, and even non-bailable warrant can be issued. But those tribunal can enforce the attendance of a person, which the proceeding cannot. Usually, my experience states that in most of the cases, when we issue notices, because summons are very rarely issued, most of the cases, notices are issued. Summons are not issued. Hardly in few tribunals they issue summons, but most of the cases they issue notices, and notices at the behest of the prayer being made by the proceeding. So this also is another one judgment. I'm not sure in which it's being reported, the Nasima's judgment, but the other two judgments relating to section 50 and 15 and oral evidence, and with regard to relationship, this Hyder Ali's judgment and Sujab Ali's judgment will suffice, which is already reported in the GLT. And with regard to, especially with regard to the females, it's very difficult to prove, because in most of the cases, they get married prior to their age of adult franchise. So there is no scope to cast vote along with their parents. In most of the cases, it's they cast vote along with their husband, not with their parents. So this is also one difficulty. So there they have to rely upon the oral evidence. They have to rely upon the oral evidence. And nowadays also, Gamburas are reluctant. It seems they were being instructed not to issue certificates. So it's very difficult. So when there is no documentary evidence, so to establish the linkage, it's very difficult. Another one prayer we can make, because in most of the orders, because this is just my experience which I'm facing before the tribunal, I'm sharing with you all. It's another one we can pray that we can pray before the learned tribunal if parents are alive. to go to pray before the tribunal for DNA test. For DNA test, which is very important. Why I'm relating? Because always, if documents are there, always it's mentioned as projected father or projected mother. But when a DNA test is there, and when parents are there, and parents is adducing evidence, and if that prayer is rejected, we can take it up to High Court. Even recently, I have filed a matter before the High Court, taking up this issue. Because it's very difficult, especially for the females, because for male, corroborative evidence can be made. Like grandfather casted vote in 66, 70, father subsequently father casted vote in the year 1979. So along with father, and always we advise our clients to take out family voters list. So we can corroborate that, like 66 grandfather, grandmother, and maybe one of the uncle of the proceedee has casted vote. His father did not attain the age of adult franchise. Then subsequently in 1979, maybe both the grandparents expired, but one of the uncle and his father has casted vote together. Then all the subsequent voters list. So if it's a family voters list is there, linkage is very clearly proved. Sometimes with regard to oral evidence, with regard to the females, suppose 66, 70 of father is there, 85 voters list of her father, along with one of her elder brother. So, and that elder brother has adduced evidence as DW2 before the learned tribunal that so and so is my sister. So this can be corroborated that 66, which she has stated, 66, 70 voters list of our parents, then subsequent 85 voters list of our elder brother along with parents, and subsequent voters list of our elder brother, and elder brother has adduced evidence. Again, we can bring in Hyder Ali's judgment about oral evidence. Because at least what I'll say is that for male, at least it's easy to establish the linkage. But for female, it's very difficult. Because all the laws are corroborated. No? If we see child marriage is still prevalent. So most of the people, they get married prior to the age of adult franchise. So no chance of female casting vote. So no if they are not going to school. Sometimes there are, because there are cases, my experience which I'm sharing, suppose a woman had gone to school but did not take out the certificate at that relevant point of time when she had studied. But subsequently, she felt the need to take out that certificate. Maybe the proceeding was drawn, or maybe subsequently during the time of NRC, she required to take out because to establish the linkage. But in a way, that cannot be discarded. If a school certificate is duly proved, whether I take it out at the time when I left the school or subsequently, that doesn't matter, but the document has to be proved. And it can make sure, because in Nasima's judgment, Honorable High Court says that it should not be half-heartedly. It should make sure that the attendance, that means the witness which is required to prove the contents of the documents, it's make sure that it's the responsibility of the tribunal to make sure, as per the rules of 4 of 1964. So these are the very two important points which I'll say about regarding the oral evidence. And section 59 also proof of the facts by oral evidence. Sometimes marriage can be proved through oral evidence if there are no documentary evidence, because most of the time there is no documentary evidence. So through oral evidence, everything can be proved through oral evidence, and which has been upheld by our Hon'ble High Court. Yes, and another one thing which I would like to share is, apart from this topic, is that if we go through the reference before submitting the written statement, it's always better than to make a rebuttal to the allegations, because in most of the DV cases, which we have noticed in doubtful voters cases, not with FT cases I'm stating, with regard to DV cases, point number 15 and 16 to be filled up is very important, which is the allegation being made by the state that so-and-so person has come from the specified territory, which is very important. Point number 15 and point number 16. It will be in annexure A of the doubtful voters cases. So those 2 points has to be filled up. So if it does not state that the person has migrated from the specified territory, which is defined as per section 6A of the Citizenship Amendment Act. So if that is not there, so merely since there is no allegation, so how come mechanically tribunal issues notices? That cannot be done. If we see paragraph 98 of Muslim Mandal, it should not be mechanical, because referring authority may be mechanical, but member while issuing notice has to go through it. In most of our cases, recent cases, because recently we are dealing with cases, most of the cases where in DV cases notices are being issued, and wherein this allegation part is not there. So when there is no allegation, so why to prove? This is one very important thing, which before stating in the, yes, he has brought in that 97, the reference by the referral authority also cannot be mechanical. Paragraph 97. The referring authority has to apply his mind on the materials collected by the investigating officer during investigation and make the reference on being satisfied that there are grounds for making reference. Honestly, I'm speaking, and you will also find that in most of the DV cases, doubtful voters cases, there are no allegation. There are no allegation.
Excuse me, Debasmita.
Yes.
Yeah, thank you for the explanation through these cases, ma'am. We've started to have some questions come in. Would you like to
Yes.
take one or two, which I can start with? And I'd also like to ask the audience that you can start raising your hands or sending in your questions through the chat box, since we'll be continuing the questions through the course of the session. Ma'am, Advocate Kamal Chakraborty from Silchar, Assam. He is asking, he has a question. He says, our FT members in Silchar don't allow oral evidence. What do we do to proceed in such cases?
We can show a hydraulic judgment, which is 2021 3 GLT. And I think you all will share that judgment, which clearly says that, and if they don't accept, we can immediately come to High Court. So this Hyder Ali's judgment, Sujab Ali's judgment, which is 2021 4th DLT, because it's a subsequent judgment. First is Hyder Ali's judgment. So Hyder Ali's judgment will suffice. Oral evidence. Yes.
Thank you for that, ma'am. Yes, we've shared the copies of both these judgments, and we'll also be sharing them at the end of the session. Advocate Debasmita Ghosh has a question. Would you like to unmute? Advocate Debasmita Ghosh. Do we have Advocate Debasmita Ghosh? Okay, maybe we can take Advocate Deepak Devnath's question and then proceed to Advocate Debasmita Ghosh's question. Advocate Deepak Devnath, if you'd like to put through your question.
Thank you. Good evening, everyone. I'm Deepak Devnath, advocate from Hojai Bar Association, Hojai District. Hello, ma'am. I have a question. Little bit, it's a confusing thing regarding that reference given by the investigating officer. Can we call him as a witness before the tribunal, as a PW, prosecution witness? Because he investigated the case. Because in few cases, we tried to do that in the tribunal number 10, that is Dawaka FT, Foreigners Tribunal, but they denied. They said it is not our duty to call them. If it is possible to call him as a DW, defense witness, but it is not possible for us to call him as a defense witness because he is the investigating officer. We tried to call him as a PW, but the tribunal, the member did not allow us.
He can be called as PW. We can call him because if required, because he is in one of my case, my experience I'm sharing, because there was differences in the inquiry report and we brought it before the tribunal. We raised that issue because there was no fair investigation when we call the investigating officer to be adduced, and he has issued summon to the IO who has investigated the thing, and he has adduced evidence, and we has asked him.
Okay, ma'am.
And
so
then
it is
he has
possible to call him as a...
Yes, we have done that. Yes.
So, but the member should issue the summon or the notice to that person, no?
Yes. Okay. Member has to issue that.
And if he is denied to do that, so what is the what should we do? If the member denied to do that,
we can come up before the High Court. Now we have a very good bench. We can come up before we are there to support.
Yes, ma'am, I know. But most of the time, ma'am, they did not allow or they did not mention in their order or the copy of the case record. They did not mention that. And if we try to put petition, then they did not allow to take it as a part of that record.
In the written statement, if we state all these things and in the inquiry report, if we, before submitting the written statement, if we go through the inquiry report, either in DV cases or in FT cases, and we give a rebuttal to it, because if there is no mere allegation, like in DV cases, in most of the cases, I have found that there is no allegation.
Yes, ma'am.
We can state in our written statement.
Okay.
We can take that plea, and if it's not considered, if we submit a petition, because they cannot say that they will not give. Either they can allow it or they can reject it. But they cannot tell the advocate that they will not give the application.
Now, most of the time, ma'am, that happened. Because I'm sorry to say that, but
I can understand. No. I can understand. Definitely. I'm with you, Deepak. I know that, sir. I know that. Because in most of the tribunal,
they are the justice of the High Court. They thought that actually.
Yes.
Like this only.
It's true, but we try to bring in all this in our written statement. If this is the reason, it's always better if we are during evidence and we state during evidence we would like to prove that proceedee would like to prove the testimony of so-and-so. We bring in all the details. This is the reason one of my request will be, because since I had dealt with so many cases before the tribunal, it's always better before, because at times we people might be busy, no time at least to go through the records, but it's always, I will request each one of you, before submitting the written statement, kindly go through the entire record.
Yes, ma'am.
It helps you to make your rebuttal.
Yes, ma'am. Yes, ma'am. Thank you so much, ma'am. Thank you so much. Thanks a lot.
Thank you.
Thank you, Advocate Deepak. At this point, I'd just like to mention that we will be sharing a Google form in the chat for you to fill in your contact details and email addresses, where we will be sharing all the judgments and the things that we have mentioned. So I request everyone to please fill in the form whenever possible. Thank you. We go to the next question. Advocate MD Asghar Ali, could you unmute yourself and pose your question to ma'am?
Hello. Good evening to all. Hello.
Yes, sir. Good evening. So we can hear you. You can go ahead with your question.
Actually, my question is relevant or not, I don't know. But one point is striking in my mind. So I want to raise this at this moment. Actually, FT case is initiated on the basis of reference inquiry report. On the basis of inquiry report that is reflected in the form of a reference. In the reference, the inquiry officer mentioned the details of the proceeding. Father name, children name, all are there. And on the basis of allegation raised or detailed in the reference, the Foreigners Tribunal initiated the case, issued notices. So can we take the stand that in the inquiry officer, father name and children name has been already detailed? That is the officer of the state, that is the inquiry officer has already detailed the details of the proceeding. Can we take the defense and in the name where the father name is mentioned, father name of the opposite party is mentioned, but during trial the father name becomes projected father. During trial, not at the stage of inquiry. At the stage of inquiry, only father name is given so and so. How come it be possible? How they collected the father name? They might have gone and inquired about it. So can we take the stand and mention in WS this factual aspect that inquiry officer has already detailed the details of the proceeding?
Because there, if I'm not wrong, there was one judgment prior to this, because sometimes parents' names are differently written in the, and which doesn't match with the proceeding. So the proceedee who appears, this is tells that this is the facts being stated by the person. Inquiry is not, there is no proper inquiry in the matter. If you take the DV cases, and I don't remember the judgment exactly. Later on, I think Rupali and all can share. There was one judgment of our High Court. Exactly, I don't remember now. Which states that its proceedee has to prove that. Okay, exactly. I don't remember, but in many of our cases before the tribunal, we see that father's name is wrongly written or son name is wrongly written. Okay, but definitely we can take up the, because if the inquiry, if they are doing it based on this inquiry, yes, definitely we can tell in the written statement that this is that. That means the father's name which is stated is true. Because sometimes the name is different. Yes. Then we take the notice which is being served, the father's name is wrongly written there. Because sometimes there are mistakes. Like in many of my cases, I have seen that. Person's name is Ainal Haq. It's written as Ainal Ali. So we clarify it. Or father's name is Abdul Sheikh. It's written as Abdul Ali. Sometimes in reference is different. So if reference is called, I can't.
Sorry, ma'am, you may continue.
Yes. So those clarification can be made in the written statement.
Yes, yes. Thank you, ma'am.
Yes, thank you, Debasmita, ma'am. I would like to call Rupali Samuel as well to supplement the answer.
Thank you for your question, Advocate Zakir Ali, and thank you so much, Advocate Debasmita. I wanted to just draw everyone's attention to Section 17 of the Evidence Act, which defines admission. So, from what Advocate Asghar Ali was sharing, I understood that the question was about whether we can also consider the correct facts in the inquiry report in the nature of an admission. If it is an incorrect fact, naturally we want to challenge the incorrect fact. But if it is a correct fact, for example, if the inquiry report or the LVO has written the father's name correctly, has written the place of birth correctly, has written the village correctly, in most instances, the place of birth is shown as within Assam and not as some kind of foreign country. So in that kind of instance, we may be able to persuasively argue that what is written in the inquiry report is in the nature of an admission. And once an admission has been made on an issue, then the state is bound by that admission and they cannot backtrack on the admission. So the definition here of admission is there in Section 17 of the Evidence Act. An admission is a statement, oral or documentary or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under the circumstances hereinafter mentioned. And Section 16 mentions admission by party to proceeding or his agent. Statements made by a party to the proceeding or by an agent to any such party whom the court regards under the circumstances of the case as expressly or impliedly authorized by him to make them are admissions. So I would submit that we should be able to argue that the inquiry officers, whoever they are, the LVO, the ERO, they are acting as agents of the state of Assam or the Union of India. They are acting as agents of the party in the proceeding, being the Union of India or the state of Assam. And therefore, if they record a certain fact or a certain statement in the inquiry report, we should be able to read it as an admission against the state, and they cannot later on try and distance themselves from that fact. Advocate Asghar Ali, is that also what you were referring to?
Yes, ma'am.
Okay, okay. Yes. We can also take out some case law on this to see if that will also be helpful.
Okay, thank you, ma'am.
Welcome.
Thank you for the answer, Advocate Rupali. We'd like to take the next question. Advocate Shahana Begum Chaudhary, if you'd like to unmute yourself and ask your question.
Good evening, madam. Good evening, madam.
Good evening.
I am Shahana from Hujai.
Yes.
Are you hearing, madam?
Yes, yes.
I'm a Shahana from Hujai.
Yes, Shahana.
One question.
Yes.
Suppose one has no sufficient documents from his or her paternal side, but there are sufficient documents from his or her maternal side. So one has produced his or her mother's documents. That is, suppose it may be 1966 Bhutanese certified copy or any other documents. But there is no linkage that she is the mother. So then mother appears before the tribunal and adduces evidence that he is her biological son or she is her biological daughter. But tribunal wants a document to prove the linkage with mother. So in such a situation, how the linkage with mother will be proved?
Through oral evidence. Mother has given oral evidence. Hey.
Mother is adducing evidence that he is her biological.
Yes. So mother is adducing evidence.
Yes.
That so and so is my son or so and so is my daughter. So
Yes.
oral evidence.
But tribunal
That
wants
means that you show the Hyder Ali's judgment, section 50.
Yes, ma'am.
As to the relationship of the section 50 of the Evidence Act, opinion on relationship when relevant.
Yes, ma'am.
Section 50. And Hyder Ali's judgment is beautiful judgment. We can rely on not only on this issue on section 50, we can rely upon sometimes like something not pleaded in the written statement. That also is clearly stated in Hyder Ali's judgment.
Yes, ma'am.
Paragraph 31, disclosure of facts. So Hyder Ali's judgment you can refer. You can Sujab Ali's judgment also you can refer. Those two judgments Rupali and all will share, and those two judgments are the vital judgment.
If mother herself adduces evidence, that will be enough.
Yes. Because
Okay,
mother is there.
Yes,
Mother has adduced evidence.
Yes, ma'am. Okay, ma'am. Thank you, ma'am. Thank you for your help.
Yes.
Thank you. Thank you, Debasmita. Advocate Devajit Ghosh, for the next question, would you like to unmute yourself and ask your question?
Hello, ma'am.
Hello.
Ma'am, this is Advocate Devajit Ghosh from Tinsukia.
Yes, Devajit.
Achha,
Yes.
ma'am, in
Yes,
FT
sir.
cases, it can be
Yes, sir.
seen it can be seen that only a notice was issued to the proceeding.
Yes.
So, ma'am, in that case, whether the proceeding appear and file a petition here, that all the documents on the basis of which notice was issued should be furnished to the proceeding, Your Honor.
You can ask for it, or you can take out the certified copy of it, or you can go through the records.
Yes.
Is the reason, because in my session I have stated, so it's our responsibility to go through the records, whether
Yes.
basic allegations are there or not.
Yes, ma'am.
So we can ask for it, but simply they won't provide. But we can ask for certified copy. We can get the certified copy easily.
Okay,
of those.
ma'am.
Yes.
I think, ma'am, it's right because
Yes,
you're
right. Yes, in Muslim portal it stated that.
Because ma'am, like civil cases,
yes,
defendant has the right to direct the plaintiff to furnish all the documents.
Yes,
Even
yes,
in
yes.
the criminal cases,
Yes,
he could
yes.
come and furnish all the
Yes,
copies on the basis of
yes,
which
yes.
state like. So
Yes,
I
yes,
think
yes.
my question here, if you ma'am, that he has the right.
Yes,
the
yes, he
proceeding
has the
also
right.
right to
Yes,
get all the documents on the basis of
Yes.
which the state issued
Yes.
the notice.
Yes, yes, you can
Yes.
get the documents.
Yes.
No doubt
Okay.
about it.
Okay, ma'am. Thank you, ma'am.
Yes.
If I may just add one point to what you just shared, the Sarbananda Sonowal 2 judgment, that's the 2006 judgment. My colleagues will just pull up the case with the citation. There they clearly say the principles of natural justice apply to the tribunal. And what you just described, Advocate Devajit Ghosh, that is an intrinsic part of fair hearing, to be able to access all the documents and be able to know the case put up against you. That is an important facet of natural justice. And when arguing these kinds of points before the tribunal, we can also show this paragraph of the Supreme Court's judgment in Sarbananda Sonowal 2 versus Union of India on principles of natural justice being necessary before the tribunal. We'll just show you the relevant paragraph. I think it may be paragraph 41. You can look at that, or you can just search. Yeah. Yes, 30 here. Principle of natural justice indisputably is required to be complied with before the tribunal passes an order. So therefore, we can also rely on this paragraph. If there is any issue about access to documents, access to certified copies, then this particular principle of law can be relied on.
Even the same thing is being reiterated in Muslim Hon'ble's case also. We can get it, all the documents, whatever is there, it's reiterated in the full bench judgment.
Okay, so maybe we can take out that paragraph also.
Okay, thank you.
So I was just sharing the relevant paragraph from the Muslim Hon'ble judgment. Just a minute. Thank you.
Perhaps you can go to the next question. Meanwhile, we'll take out the paragraph.
Anyone with questions, they could please raise their hands, and then I could approach you to unmute and then take your question. Or you could also send your questions in the chat box. Also, we urge you to ask your question in whatever language that would be comfortable with you, in English, Hindi, or Assamese. We have a member from the Parichay team who has a question. Lakshmi, would you like to unmute yourself and ask the question?
Yeah, thank you so much. I just had one question. So, I wasn't really clear about where the requirement for producing documents in proving linkage is coming from. So, is it from any specific provision in the FT order, or are we looking at certain Evidence Act provisions here? But where is this requirement coming from in such a way that oral evidence is getting rejected by the FTs in terms of proving linkage?
So, linkage, because since the burden of proof is upon the proceedee, as per section 9 of the Foreigners, the burden is upon the proceedee to prove that the existence as per that prior to 1/1/1966. So for that reason, if a voter's list is being exhibited or whatever, maybe a land document, it is not mandatory that only voter's list is exhibited. Land document is exhibited, or any other document, old document is exhibited, and so person. So linkage between so person and the proceedee. If there is no documentary proof, so the person is so. So where from she or he will prove that. So for men, it's always this is the reason it speaks about section 50 of the Evidence Act, relationship. to prove through oral evidence, opinion on relationship, whether relevant. And if tribunal is not accepting, because earlier tribunal, now this Hyder Ali's judgment. Hyder Ali's judgment clearly says that. So which is very important. Am I clear, or would Rupali like to substitute something?
Very clear.
No, it's because suppose so and so documents, it has to be proved, no, that so and so is my father. Suppose if I give voters list or a land document of 1966. So to establish this linkage, if there is no documentary proof, then to prove through oral evidence.
Understood, ma'am. Thank you so much.
Yes, welcome. And especially, which is very important for females, to prove, give a documentary proof, which is very important, the acceptance of oral evidence.
Thank you, Debasmita ma'am. We have another question in the chat box, Debasmita ma'am. I'll just read it out by
Yes.
Gayatri Gupta. In the oral evidence by the parent or relative, are there any specific things that they should mention in their testimony so that it is more likely to be accepted by the Foreigner Tribunal under Section 50 of the Indian Evidence Act?
Yes, has to state the conduct. That means to description. Suppose if a mother is adducing evidence, or a relative, mother too is very easy. But suppose a relative is adducing evidence. So she is my niece. Suppose our uncle is adducing evidence. So clearly has to state that she is daughter of my elder brother. So she was born and so year, and she brought up in the same family, because if it is a joint family, so everything has to be clearly stated. Or during childhood, she used to call me that by so and so uncle, and I used to call her by so and so. So all the relevant facts has to be stated, because there is no document that so and so is the uncle of so and so, but facts through oral evidence. So all these things has to be clearly stated in the evidence. So facts has to be clearly stated. Facts, staying in a family, brought up, the way the child was brought up. So these all, if the facts are clearly stated, it's easy. And even section 50, and then we can see even in section 59, it says proof of facts by oral evidence. So facts can be proved through oral evidence. Yes.
Thank you, Debasmita, and thank you, Gayatri, for that question. Do we have any more questions that people would like to send in? You can either raise your hand and I will approach you to ask your question, or you can place it in the chat box. I also urge again that if you have not filled in the Google form, to fill in the Google form so that at the end of these sessions, we can send you all the material that has been referred to in these sessions, including copies of the judgment and excerpts.
Debasmita ma'am, I want to ask a question. If you can maybe share a little bit about preparing witnesses to appear before the tribunal. Now,
Yes.
We have this window in the form of Section 50 and the judgments of our Honorable High Court to utilize oral evidence. But all of that depends on the witness actually being able to come to the court and depose and withstand cross-examination. So could you share a little bit about that aspect?
So whatever the facts, we should make sure that we explain whatever is written because facts, the witness will state. So same thing will be written in the evidence in a written form while submitting the written evidence on affidavit. And we each line by line, suppose we explain the witness, we prepare the witness mentally, what all probable cross will be done. Means cross questions may come in. We explain whatever is written in the evidence on affidavit, the facts which are being stated. Sometimes it's for them, when a witness come to adduce evidence before the tribunal, for them it's like an exam hall. When we used to enter in an exam hall with the way we feel, the nervousness, they the same way as a student, always we feel the nervousness. But I felt that, I don't know about others, but I felt that the nervousness to write an exam. For them also, it's the same thing. They are scared to enter in. So if we mentally make them strong and we explain each and because facts, they know it very well, because more than us, because if our uncle is coming, so uncle will know better, because since childhood or since the child was born, proceedee was born, has seen the proceedee. So stating the facts for them will not be difficult, but we have to prepare them. The sequence, whatever is written in the evidence on affidavit, if we explain them well, and the probable questions which might ask, sometimes they ask, okay, what is the age difference between the elder brother and the proceedee? Because these are the probable questions they ask during cross-examination to shaken the credibility of the oral evidence. So if we make sure that confidently, if they can reply back to the question being asked by the prosecution witness, by the SGP, whatever they ask. So facts, they should not forget. Sometimes they tend to, even other day in the court, because a mother had come in to adduce evidence. She became nervous. She was about more than 80 years old. So she was nervous, so she couldn't state when your son was born, year. She couldn't state. Then she could state that at present my son is so and so years. So she could not state the year of birth, but she could state at present my son is so and so years. So these, we prepared her. And sometimes we prepare the witness because they don't remember the year. So they don't remember the year, like 1985. Suppose the proceedee was born in the year 1985 and mother has come to adduce evidence. Then we tell Sarikuri pass. That means Sarikuri means 420. That means 80. Then 5 is 85. So we explain, means we prepare the witness. So whatever question is being asked, they can state clearly before the tribunal, which is very important. Because simply whatever we write in the evidence on affidavit, and if we submit that, and if we don't prepare our witness, and when the question is posed, that is difficult. So especially with regard to oral evidence, I will say that they have to be very firm. So they have to be prepared well before they are being cross-examined before the learned tribunal. So this is very important. So in their language, because they might not understand the English letters, or if we say 1985, they may not be able to state that. But if we explain in their terms and conditions, like they understand, no, because these are the colloquial languages. So they understand. So if we make them understand. And even the years, we explain them. So and so 4 coms. If it's like 1980, or 76, the proceeding is born. So if we explain them, if they say Asir pora sari kom, these are the techniques we we as a lawyers we teach so that they exactly or accurately they state before the tribunal when cross-examination is done. So to prepare a witness is really a very important thing.
Thank you, Advocate Debasmita. I cannot imagine how challenging it is to help someone navigate the hostile atmosphere of a courtroom. In any instance, persons from any walk of life are always scared to be in a courtroom present. So our job is to also make the person feel more comfortable. And one avenue that may be helpful is even during the course of the deposition, if there are certain errors that have been made by the person, they can always clarify them. Even if a contradiction comes, the contradiction, if it's a minor contradiction or it can be explained, the witness can always explain the mistake. Or even after cross-examination, there can be re-examination of the witness. So you can also ask to, to come back and to conduct re-examination of the witness, and you can clarify any mistakes. And if the witness is able to say that, no, that was a error, that was a mistake, and they remember correctly, and this is the correct, or the witness wants to give the answer in the colloquial or vernacular, that is also possible. And you can request the tribunal member to also record it in the vernacular or in the vernacular word, especially if it's like you're explaining age and those kinds of numerical facts. So, and on that point, maybe actually, if you can share a little bit about inconsistency or minor contradiction. That minor contradiction is not a serious issue in evaluating evidence, but we have also seen many cases where, based on minor contradiction, the entire testimony is discarded. So maybe we can, if we can request you to share a little bit about that.
That can be, yes, definitely that can be clarified if minor discrepancies are there, that can be clarified. Or if there is nothing being rebuttal to it, suppose evidence has led, cross-examination is not done, and there is no rebuttal to the evidence led, then it's admissible. And recent judgment also, it has stated that, because state, they also don't rebut. And with minor discrepancies, in most of the cases which I have dealt in, they ignore. Like date of birth is suppose 2 years, they could not, or 1 year difference, exact whatever is led in the evidence on affidavit. And while stating suppose 1 year this way or that way, that has been ignored. Otherwise, in most of the cases which we are dealing with, my experience. But yes, definitely, if there is any mistake, obviously we can ask for re-examination, or that can be clarified. Even that can be clarified by the later on, even it's quoted also, because sometimes they may not understand the language. They come from remote area, they understand their own dialects. So when it's being explained in their own dialects, then it can be recorded. So that as a lawyer, we can ask permission that so and so couldn't did not understand. So in even we have done in our cases, and the later on the witness has stated that it's recorded in the evidence. So that can be clarified. Definitely, that can be clarified by the witness. Yes.
Thank you for answering these important questions in terms of preparing witnesses and minor discrepancies, which definitely come up in multiple number of cases. But good clarification for most of the people engaged in this litigation. Do we have more questions in the room? We can just do one last call for questions, and if we don't have questions, then we can look at wrapping up the session. Is there anyone who'd like to ask a question by raising their hands or by dropping a question in the chat box? Okay. Then we'll look to wrap up the session now. Once again, thank you so much, Debasmita ma'am, for taking the time out and explaining these things in very minute detail and bringing a much needed subject to the fore in terms of things you want to put out. Mr. Tariq Ansari has a question actually, so we'll probably just quickly take that and then proceed to wrap up. So Tariq Ansari, if you want to unmute yourself.
Yes. Actually, today what happened that I shared your link twice last time. The third time also I shared your link, but it was old link. So many tried to enter your program, but they could not enter. So I would like to have your number so that I can get your link tomorrow correctly, and I will share. So many advocates were asking me that it was the link was coming invalid. This happened today.
Thank you for mentioning that, Mr. Tariq Ansari, because we will make sure to circulate the link to everyone. And we had done that to everyone who attended the previous sessions. We'll just make it a point to send the link for tomorrow's session to everyone who attended last week's sessions as well.
I filled up the Google form also. My phone number is there. And
absolutely. Yes.
Okay.
Thank you so much. Again, if there are no more questions in the room, we can proceed to wrap up the session. We'd also like to just remind everyone that we have a session on the final arguments in Foreigner Tribunal cases tomorrow that will be hosted by Advocate Zakir Hussain and Advocate Talha Abdul Rahman. The timing will be 6 p.m. to 8 p.m. tomorrow evening. And we again ask you to fill in your names in the Google form so we can circulate the link to everyone who's been present in these sessions. And again, we'd also like to thank Advocate Zakir Hussain for attending all of our sessions very avidly. And since he'll be conducting tomorrow's session, he's also present in today's session. And again, we hope you all have filled the form and sent in your contact details. I'd also, at this point, I would like to hand over to my colleague Sita for giving the vote of thanks for the session.
Good evening, everyone. All of us at Parichay would like to thank the dignitaries, speakers, and lawyers who've attended the third session of our lecture series on foreigner tribunal practices. We would like to express our heartfelt gratitude to His Lordship, the Honorable Justice N. Kotiswar Singh, for his generous and continued support for the program. We also sincerely thank Advocate Debasmita Ghosh for conducting this crucial session and for sharing her experiences. I'm sure that it has helped us understand how to approach cases in the FTs where there is not sufficient documentary evidence, and especially for highlighting the issues that come up with gender. We would like to thank the Assam State Legal Services Authority for collaborating with Parichay. We would like to thank Sri Nayan Barua, Member Secretary of the ASALSA, for his support in organizing this series. We also want to extend our gratitude to Sri Tripti Ari, the Deputy Secretary of ASALSA, and Sri Aishri Shravan, the Undersecretary of ASALSA, for their generous and proactive support. We want to thank Darshana Mitra, Rupali Samuel, and Shatul Gopuchkar for moderating this session. Lastly, we express our heartfelt thanks for your interest in participating in this program. And we hope to see you soon at the 4th session tomorrow, where we would be discussing the presentation of final arguments in FT cases. Once again, please fill out the Google form that has been shared for a copy of the judgments that we've discussed. And we're also sharing the YouTube link to our channel so that you can watch or rewatch the sessions. Thank you once again for attending. See you all tomorrow, hopefully. Thank you.